prosecutors as leaders of reform. My name is Mark Soler. I'm the Executive Director of the Center for Children's Law and Policy in Washington, D.C. This webinar is a replication of a well-received workshop that was held at the JDAI Intersight Conference last year in Seattle. And we have more than 300 people signed up for this webinar today. We often in JDAI don't realize that prosecutors have enormous power in the justice system. They get to decide which charges to bring, including deciding how strong the evidence is and which witnesses are credible. They decide on the number of charges to bring. They make recommendations regarding detention. They decide which plea bargains to offer and which plea bargains to accept. In disposition, they make recommendations, including conditions of probation, and they make recommendations to the court if a youth violates probation or other court orders. In recent years, we've seen the rise of reform-minded prosecutors in major cities around the country: Philadelphia, Seattle, Houston, Brooklyn, Baltimore, Boston, and in Ferguson, Missouri, and in counties in Northern Virginia, as you could tell from the blog I wrote for JDAI Connect. And this is going on in a number of cities and counties all over the country. It's really a new vision of prosecutors as leaders of reform. And today we have three of the best. John Jordan is the Juvenile Division Chief in Harris County, Texas. That includes the city of Houston, in the District Attorney's Office. Philip Sanchez is the Senior Deputy Prosecuting Attorney in the Juvenile Division in King County, which is Seattle, Washington, in the Prosecuting Attorney's Office. And Robert Listenby is the First Assistant District Attorney in the Philadelphia Office of the District Attorney. They're going to talk about their approaches to juvenile justice reform, what they've been able to accomplish, and the challenges that they've faced. But before we go to them, we're going to do a quick survey, a quick poll, and Beth is going to bring that up. This will just take a minute. Beth, go ahead and bring up the poll. All you have to do is click on your answer to this, and we'll do a quick tally of what those are. So go ahead and fill out that poll right now, and then Beth is going to tell me what the results are so that I can announce them.
Yeah, Mark, we've got 66 of 109 people voting so far. So your words carry great weight. When you ask people to vote, they do.
Okay. We've got a lot of people voting now. So, and those of you who have logged on, go ahead and vote in the poll.
And everybody should see the poll, Mark, which is your prosecutor engaged in your reform efforts? And people are to submit either yes, no, or they're not sure, and we appreciate honesty. So we have 79% of the people voted. We just hit 80%. So you let me know, Mark, if you're ready for me to end the polling and to show you the results.
Okay, we'll give it another few seconds, and then we'll go ahead and announce it. Okay, Beth, how are we doing?
We're doing good. We're still at 80%, but let's go ahead and keep moving. I'm going to end the poll, and I'm going to share the results, and you guys should see the results.
Okay, so the results of the poll are that 48% of the respondents, that is 46 people, said yes, their prosecutor is engaged in reform efforts. 19%, that is 18 people, said no, their prosecutor is not engaged. And for a third of the people, they said, I'm not sure. So in your JDAI sites, one thing to do is find out if your prosecutor is engaged in reform efforts, and if they're not, invite them to join in. So we're going to get started now with having our speakers. First up is John Jordan from the Harris County, Texas Prosecutor's Office. Go ahead, John.
Good afternoon, everyone. Like Mark said, my name is John Jordan, and I'm with the Harris County District Attorney's Office. To put in perspective, Harris County, which encompasses Houston, there was a day 10 years ago where we led the nation in capital murders, led the nation in the death penalty. In fact, they used to say that if Harris County was its own state, we would be second only to the state of Texas in the amount of death penalties that we would give out. Why do I say that? I say that to say if reform can happen here, it can happen anywhere, and we're extremely excited about it. I've been a prosecutor for 20 years. For 18 of those years, I was only an adult prosecutor. I'd prosecuted murders, capital murders, and aggravated sexual assaults of children. At least 50 jury trials in those areas. 2 years ago, my district attorney, Kim Ogg, asked me to take over the juvenile division, and I had never stepped foot in juvenile before. And I think that was a good thing for me because I had a perspective of what really violent, horrible crime is. And when I got here, I could not believe what I was seeing, the overcharging of youth. Now, we do have an aggravated robbery problem. We do have youth that commit violent acts, but it's such a small percentage, as you know, and we had been charging way too many youth. So she gave me a goal. I had to reduce the footprint and expand diversions, and that's why I'm here to talk about, because we have done that over the last 18 months. The first thing we did is we looked at the data, and for the 3 years previous to me taking over, we had 11,000 referrals and 8,000 petitions filed. That was consistent every year. So we had the benefit of being a direct file state, and what that means is a police officer cannot make an arrest unless they speak to a DA over the phone. We have intake procedures where they have to call us 24 hours a day, 7 days a week, on the side of the road, at a school, wherever they are, for us to accept charges. So that gives us a great opportunity to affect the amount of cases that are coming in. So one of the things we did is we changed the criteria in order to accept a case on a juvenile. As we all know, officers and prosecutors across the country, when it comes to adults, all we care about are the elements of the crime met? Is there probable cause to believe this occurred, right? Well, for a juvenile, we actually put into our manual, and I'll read it to you. It says, in determining whether to refer a juvenile to the juvenile justice system, the prosecutor should not only be concerned with protecting the public, but also with what is in the best interest of the juvenile, recognizing that the decision may have a dramatic impact on the course of the juvenile's life. That is in our manual. And then so beyond probable cause, what is required is you must consider the nature of the misconduct. This is a catch-all. And again, even if a youth has committed a crime and committed probable cause and all the elements of the crime, you're supposed to look at the nature of the misconduct. Is this youthful behavior? Meaning, yes, we would charge an adult, but maybe we shouldn't charge a juvenile. Things such as criminal trespass, assaults, things of that nature. What I like to tell people is how many people have ever had a street sign in their garage? You know, if an adult did that kind of conduct, you'd be really offended. Youth used to do that all the time. We did it as kids and never got charged. We also look at individual factors, which are age. Are they 10, 11, or 12? Or are they 15 or 16? Do they have a disability? Are they autistic? Do they have ADHD? I even consider individual factor. Are they in CPS custody? They deserve some benevolence. And then lastly, even after all those things are analyzed, is there a diversion that's appropriate? So we took that and then we went on a tour of training. We trained ISD police officers. We have 11 different ISD police departments. Our Houston Independent School District has 208 officers. I asked each chief, give me your entire force over the summer and I will train them. And we did so. Then we took it one step further. In our larger jurisdictions, we spoke to the principals and the assistant principals. At the Houston Independent School District, the superintendent allowed me to speak to every principal of every middle school and every high school in the city of Houston. And in that endeavor, we created a video, a 20-minute video of a mock arrest of a youth. We actually used my son, who's 12 years old, Samuel. And we literally went from school to processing to the Juvenile Detention Center. It is linked to this website, to JDAI, as well as this training, is my understanding. But if you go to YouTube and put in what happens when a school decides to arrest a juvenile, you can pull up that video. To date, it has 3.7 million hits. And when you present it to educators, you can cut the room with a knife because they mistakenly think, I call the police, I want the kid, they think they're going to get help, and they are forced to look and see exactly what happens to a youth. Now, we have done an analysis of the data, and we knew that 40% of all of our cases came from schools. So that was going to be a big focus. And so with this endeavor, we can have some results that we'd like to share. If you compare 2018, the fall of 2018 to the fall that we just had in 2019, our school filings are down, referrals are down 38%. And of those referrals that come in, we only file petitions in court on 40%. We are actually diverting 48% of those school cases. And actually, when they come in and I review them, there's 12% of them that are rejected. So we are making great strides. It's a cultural change. It took about a year and a half, but I believe we have buy-in from school administrators as well as school officers. The next thing we did in my last few minutes is we've expanded our diversions greatly. We have a general diversion program that usually is for first offenders. A lot of these schools, all the school diversions go here, where they go to a night, we call it juvenile consequences, in which I speak to them, a defense attorney speaks to them, probation officer speaks to them, a youth, well, someone in their 30s that was certified as an adult that went to youth prison and transferred to our adult system to speak to them about don't go down this path. And then if they remain arrest-free for 90 days or 180 days, we never file the petition. It has an 87% success rate. And when we say success, we mean they never pick up another case before they turn 18. Now, we've expanded it since I got here. It used to be Class A's and Class B misdemeanors for 10 years. We've expanded to all misdemeanors and all nonviolent felonies. So we're hoping to keep that same success rate. The next diversion program we created, which is the first in the nation, we partnered with our Children's Assessment Center, and we created a sexual assault diversion, it's called BASE, Building Appropriate Sexual Education. And those are sexual assaults that happen within the home, relatively close in age, step siblings, half siblings, siblings, in which we believe most of them are victims themselves. They aren't predators, they are truly just sexually acting out against the law. But instead of filing on them, we've partnered with the Children's Assessment Center and we get them individual therapy for 6 months and then in lieu of filing. Now, we still file on sexual assaults if we believe the behavior is worse or they need more than 6 months of counseling. But to give you an idea, in any given year, we'll file 60 or so sexual assaults cases, and then we put about 25 additional people on diversion. The next diversion program we have is called the FIRST program. And Philip will talk to you next, but we stole the program from Seattle. They call theirs FIRS, which is Family Intervention Restorative Services. We added a T on the end. We call it FIRST because we call it Family Intervention Restorative Services of Texas. And what it is that when a youth assaults their guardian, their parent, their grandparent, and the police are called to the scene, we still authorize an arrest. They go down to juvenile detention. They have to stay in juvenile detention for 24 hours. But then we have our mental health folks, which is the Harris Center in town, will reach out to those families within 24 hours, offer them services, and if they agree to take their youth out of detention within 48 hours, we'll put them in this program, never file a case, and give them the services they need. So far, it's been in existence for a year, and we've put 300 families on this program that previously would have been in jail for over 6 weeks or more, as well as a case being filed on them. And from what the folks tell us, the parents need the services just as much as the parents, as the children. They're misdiagnosed. 2 more quick programs, then I'll turn it over. We have the marijuana diversion program, which is the only program where it's not an arrest at all. What we tell them, if you seize the cannabis, you then contact the youth's parents. Juvenile probation is a partner, and we tell them if they attend a 3-hour Saturday course that we partnered with the Houston Council on Recovery that talks about the dangers of marijuana on the brain development, developing brain, dangers of vaping, then we'll never file a case. We expect that to affect about 1,100 kids a year, and that's a new program within the last few months. And then lastly, we have our first school diversion specific program, very poor area, but revitalized area of the 5th Ward in Houston, in which a lot of folks within the community came to us, and because they wanted to do mentorship, they wanted to help the youth in their community. And we developed a program that every school within the 5th Ward, it encompasses 3 high schools and 2 middle schools, that if you commit a crime on those campuses, other than sexual assault or anything involving a firearm, we're going to divert you. And you will be diverted back into your community, and they'll do a restorative justice model. And it's a 6-month program. So we have greatly expanded these diversions. We can see on the horizon, we're going to do a dual status diversion program, CPS custody kids. And we're really excited about the things that we're doing about it. I'm passionate about it. And I think I've taken my full 10 minutes, Mark.
John, that was great. A couple of questions came up while you were talking. Could you give the names of the sexual abuse diversion program and also of the domestic assault diversion program.
Yeah, yes. The sexual assault diversion program, again, we partner with our local Children's Assessment Center, and it's called the BASE program. It's called Building Appropriate Sexual Education. And according to the Children's Assessment Center, we believe it's the first one in the nation. The second one is our family violence diversion program, and we call it FIRST, which is Family Intervention Restorative Services of Texas.
Great. One other thing, the question came up when you do the trainings of your police officers, where did you get the financing to do that training?
The financing of I went out there and did the training for the ISD Police
It
Department.
was your salary.
Yes.
Terrific. Great. Thank you very much. Now we're going to turn to Philip Sanchez, who is the Senior Deputy Prosecuting Attorney in Juvenile Court in King County. Philip, go ahead.
All right. Thank you and greetings. Thank you this morning for having me to be a part of this webinar. And I just definitely want to say thank you to all of those who are watching and involved in the juvenile justice system, especially those that are also tirelessly working as prosecutors, because there's never a shortage of cases or kids that come through our system. But I think as a prosecutor, you have to ask yourself, what if there was? What if there was an opportunity where we can kind of change what we're currently doing now to see if there are ways that we can minimize the amount of cases that come into our system, but be able to provide services to youth as well as their families, because kids are complicated, right? The work in the juvenile system is not just focused on the youth, but oftentimes what happens at home leads to the decision making that happens outside of the home. There are reasons why kids don't want to be home. There are reasons why maybe their parents have a mental health issue, maybe the child also has a mental health issue not being addressed, and so forth. So it's always complicated. But I think we always need to ask ourselves as prosecutors, right, are we doing enough? Not just sort of meeting what our stats may show, but are we doing enough to maybe change the future? What are we doing tomorrow differently? I'll just kind of generally share that the climate here in Seattle, one, is always rainy, but two, with regards to juvenile justice, a couple of things that are going on over here that started more than a few years ago, or just about a few years ago. A few things. Obviously, we have the same amount of gang violence, gun violence, concerning cases involving youth that sexually offend. But what we're also addressing right now in King County is what we call zero youth detention. This is phrased as a movement, but it's also actually a project and a commitment by our King County executive to address as a public health issue. Zero youth detention. How can we eliminate or significantly reduce the amount of youth in our detention system? Because we also know that traditionally and historically there's been disproportionality amongst certain sections of the community that are in our system that we are routinely seeing. So what are we doing? John said something really important earlier when he presented, and that's data, right? He threw out the word data. Data is very critical in what we do. I think we all have a sense of sort of what our cases look like, what our caseloads consist of, but until you really run the numbers, do you really know what you have? And so 2017 was kind of a critical year where we ran a lot of data, and that led to a couple of programs. One of those programs was FIRST, which is what John referred to in his presentation, which again is the Family Intervention Restorative Services. What we found in our data when we ran our case information is that we found that 90% of our domestic violence cases involve family members. Okay, not so much sort of the teen dating, but more amongst mom, dad, or maybe even sibling. We also found that 70% of those cases often involved mom. So sorry, mom. But when we looked at our caseload, okay, it actually really only made a relatively small portion, 15% of our actual caseload. But what we also found when we looked at bookings, we found that it made actually 32% of all new bookings. And I think in all of our experiences, we often have parents who there's a repeated history of domestic violence within the home that finally escalates to the point that a parent calls 911 just so that their kid is taken away, arrested, out of the house. I don't want to deal with them. I'm tired of it, or maybe something more serious happened, of course. And so the youth were arrested and then they were detained. And then, what would typically happen in the next 72 hours is we're trying to figure out, are we going to charge them? Are we going to hold them? We had parents sometimes that come back 24 hours later saying, I'm not going to be involved. I'm not going to give a statement. I don't want to press charges against my son or daughter. I want them to come home. Some also have the opposite effect, which is, yes, I do want to prosecute and so forth for whatever the reasons that may exist. So we're trying to figure out what 32% of new bookings consisted of these youth. And so what can we do differently for those families and those youth in these very difficult situations? And so the Family Intervention Restorative Services, what we ended up doing, and this was really at the lead of our chief of the Juvenile Division, which is Jimmy Hung, as well as our lead legal operations manager, Stephanie Trolin, is that with all of this data, right, you can present to others, right, what are the numbers and why do we have this need, that there's a need that exists here. And from that, you can justify or be able to get others to support sort of the financing that goes behind it. For example, first has the Office of Public Defense involved, the county's Adult and Juvenile Detention Division involved, all contributing right to this project of Family Intervention Restorative Services. So what happens is that when a youth is detained and looking at their history, presumably again, there's very minimal significant history, then they go to a respite center in our detention facility. So not with sort of what the other kids would go to when they're normally arrested. It's a respite center. This youth can leave and come and go as they wish. There's a bed, there's a room, there's books, there's magazine, there's cool art on the walls. And as soon as they get here, they're meeting with a first team member who will meet with the youth to kind of figure out what's going on at home. What kind of safety issues or concerns or what abuse are they suffering? What is going on in the house? At the same time, after the arrest, the parent, as John mentioned, the parent is immediately contacted within 24 hours as well from, again, a first team member to talk with the family member again to get more idea about the history behind what was going on in the house and so forth. And then from that, both the child and the parent have to come to an agreement that they will engage in services, develop a safety plan going forward. And that as part of that agreement, right, we will, as the prosecutor, will agree not to move forward with the case. And so we ended up reducing the number of filings that we had, which ultimately also reduced a lot of the trauma that families go through when cases are pending. And now, for example, later they want to pull out, they don't want to harm their child. It's a very difficult position for parents to be in. And so that's one solution that we came up with, is how do we address or minimize the detention bookings or unnecessary detention bookings of families in those difficult circumstances. In 2017, though, we also took a look at more of the violent crimes. We took a look at, what can we do right now to address those crimes as well? They make up a bulk, the robberies, the serious assaults, some of the property crimes as well. So we ended up developing a program called CEDAR, which is the Community Empowered Disposition Alternative Resolution. That's a long way of saying we like trees out here. We've got firs and now we have cedar. And so what that really involves for us is we took a look at, okay, what percentage now are of the serious crimes, the ones that involve those robberies or assaults, and how many of those kids are first-time offenders? Because as a prosecutor, typically when you get those cases, you're concerned. This kid has no history, and all of a sudden now they're in front of me for a robbery in the second degree. What's going on, right? And maybe they're 16, so they're well into their teens, almost late teens. So you're now saying, what's going on? This kid is not anywhere. We don't have any history. What's going on? What can we do? Because what obviously none of us want is for them to come back because of maybe now this crew they're running with or influences around them, that they'll be back with another rob too. So how do we address that? How do we figure that out? So what we ended up doing is, because it's called, again, Community Empowered Disposition Alternative Resolution, we figure out what community partners can we gather together here to provide services for that youth in the community while they're now in the criminal justice system. So that means they've been charged with the crime. Okay, what can we do now? So for generally first-time offenders, for youth that even have a robbery in the second degree or assault in the second degree and more high-level crimes, we tried to figure out what services do they need in the community. So what happens in those is this: upon filing, again, if they meet some criteria about lack of risk to the community, minimal history, we meet the prosecutor with a defense attorney and a probation officer to discuss whether this youth would be a good candidate for this program. They're trying to assess what's going on in the home, what's not going on in the home, what's going on the street. And from there, if we decide that they're a good candidate, what we do is we offer a immediate reduction to that youth from the beginning. We say, we're charging with Rob and Ree in the second degree today, but we are willing to reduce down to theft in the first degree if you accept this agreement that you're going to engage in these services. And again, this is after everyone's kind of approved that we think this kid will be a success at doing this, or will have the support and services. Once they agree to good in that contract, they have, again, their probation counselor, but they also have, again, our community partners. We partner up with credible messengers. Maybe some of you have heard about them. We have them here in our communities, people who are investing back in their youth, young and old, who want to mentor and support not only the child, but the parent as well. And so they're working with youth and giving the probation officer and prosecutor and defense attorney updates about the successes. And so what we say is, okay, you complete the theft in the first degree, we'll reduce if you agree to take part in this program. What we will do though is we will set out your sentencing hearing, okay, 4 to 6 months. Let's see how you do in this program. Now, depending how they do, and that will actually be determined by the prosecutors, if they do well or graduate the program and turn things around, or also engage in restorative mediation with a victim, for example, in a case, we can get them to that point. At the sentencing, again, 4 to 6 months later, what we will do then is allow them to withdraw their plea of guilty and plead guilty then to an even further reduced charge. Sometimes it may be to a gross misdemeanor or misdemeanor. In some cases, it could even be a potential dismissal. It just depends how long that process will take. But it's a way that, again, that we can try to address what do we do with those first-time offenders who come into the system, give them the support that they need so that they don't come back in and reoffend. So those are a couple of the programs that we've developed out here in King County, and you know, we're always trying to look for more solutions to not only the diversion process, right? How can we divert more youth, but also get them services? But what are we doing with our active cases? What are we doing with our cases that are in the system? How can we better serve or more creatively serve those victims or youth involved?
Thank you, Philip. Some questions came up while you were talking about the names of the first program and the SEER program. Can you spell out what each letter stands for?
Sure. So for the FIRS, that's the Family Intervention Restorative Services. And for CEDAR, that was the Community Empowered Disposition Alternative Resolution. So again, CEDAR, correct. The alternative sort of being, you know, we're engaged with the community sort of being that alternative, right? We're now engaging with people in the community who, and a part of that is building trust with those partners, right? You have to trust that they're honestly reporting kind of how the youth is doing, checking up on them almost daily. And I should also add that for CEDAR, what's also really critical is that component with the parent, because the CEDAR or credible messengers that we work with, they're not only sometimes even driving the youth to court to make sure they make their hearings, they're making sure the parents are there too on occasion, or reminding them, or being the ride for everybody to get here to court. Because again, when working with families and youth, it's complicated. And we all have seen cases where there are youth who are clearly struggling with being able to succeed on their cases, showing up for court and so forth because of what's going on at home as well.
Great, thank you. We're now going to turn to Bob Listenby, who is the first Assistant District Attorney in the Philadelphia District Attorney's Office. Bob, go ahead.
Thanks very much, Mark. I want to thank my colleagues, John and Philip. John, Philip, and I were together when we did this out in Seattle, and we had quite a good time out there. I want to start by stressing a couple of things. First, many of you out there are interested in hearing more about diversion programs and other types of programs that are being developed across the country to address issues of reducing the number of youth in our juvenile justice system. I want to invite many of you who have an interest in that to come to a progressive juvenile conference that we're going to have here in Philadelphia, April 29th and 30th and May 1st. And it's going to be sponsored by the Philadelphia District Attorney's Office. We're seeking additional funding to pay for some of the costs of the conference. But if you're interested, please contact Sarah Shaw, and you can reach her at Sarah, S-A-R-A-H, .shaw, S-H-A-W, at phila, P-H-I-L-A.gov. That's sarah.shaw@phila.gov. I want to start off by talking about why I am here. I am a former public defender who worked as a public defender for 27 years, head of the juvenile unit of the Philadelphia Public Defender's Office for over 16 years. Unlike John, who has been a prosecutor for 20 years, I've only been a prosecutor for 2 years. And I'm part of the Larry Krasner's administration here in Philadelphia. We're engaged in progressive prosecution and completely reforming the entire criminal justice and juvenile justice systems simultaneously. We're focused on doing a couple of things in the area of youth. First of all, there are 4 separate systems that we're taking a look at simultaneously. There's a direct file system for young people who are 14 years or older, between 14 and 18, who are transferred to the adult system. Our goal there is to send almost all of those kids back to the juvenile justice system. There are a few that we keep in the adult system, and I'm available to have a conversation about the criteria that we use for sending them back and what we do with them when they get back to the juvenile justice system. In the juvenile justice system, which in Pennsylvania goes between the ages of 10 and 17, our goal is to have all the young people who are under the age of 12 or between the ages of 10 and 12 diverted out of the juvenile justice system. So we're seeking diversion for all of those young people. In addition, in the juvenile justice system, our goal is to divert as many of the misdemeanor cases as possible out of the juvenile justice system. I'm going to talk more about some of the programs and some of the concepts that we're using for addressing our juvenile justice reforms in just a moment. But I want to mention the other 2 systems that we're looking at. We have summary offenses here in Pennsylvania. Many youth who are arrested and charged with summaries, these are offenses where you can get up to 90 days in jail. Many of them, for a variety of reasons, don't come into the juvenile justice system. But if they are actually convicted of the summary offenses, those offenses will be on their records for the rest of their lives. So we're engaging in a process of looking at those offenses and trying to figure out how we can avoid them and prevent them from coming into the adult system where they get summaries. And finally, there's the 4th category of young people, ages 18 to 25, young adults. We're looking to develop a comprehensive program for addressing young adults. Now, throughout all these 4 different areas, we have a few overarching concepts. One is adolescent development. Many of you are familiar with Reforming Juvenile Justice, a developmental approach, the National Academy of Sciences publication, which talks about why we need to think differently about young people, no matter what we're doing with them, young people between the ages of 10 and 26. We're also looking at addressing the issue of trauma, using trauma-informed care wherever appropriate. We think that that's critical. We're also looking at data because we know that data is critical for determining whether or not your programs are successful, and also evaluations. And the one thing that we do with a variety of policies, some of which I'm going to talk about and some I'm not going to get into, is we look at using an individualized approach to all of our cases with a series of presumptions. So when I say that we want to have almost all the kids out of the system under the age of 12, there's a presumption there. There are some cases that we might find that we want to keep in the system for a variety of reasons, but the presumption there is there, and it's pretty powerful. As we look at what we're doing, DA Krasner started off in his campaign talking about the need to have almost all children who are arrested in the adult system sent back to the juvenile justice system. And for the first 2 years under his administration, the overwhelming majority, I'm looking at over 70%, have been sent back to the juvenile justice system. And there we've been focused on new approaches to dealing with some of the young people who come back. Many of them have been arrested for violent offenses. We believe fundamentally that there are ways of treating them within the juvenile justice system, most of them in the community, but we also need new types of facilities that where we can send kids close to home where they can address the issues related to their violence. And we're focusing on working with our judges and our community resources here to develop those kinds of institutions in the Philadelphia area so we can address the unique needs of our young people and the adults who come back from the adult system. In the juvenile justice system, we have been involved, engaged in reform for most of my tenure here. I was working with a prosecutor, George Mosey, who many of you may know, and George was a progressive prosecutor in a sense. we have a bigger mandate under DA Krasner than George had, so we can do more. But with George, starting back in 2001, we reduced the number of petitions in the system from 10,000 down to about 2,400 when this administration under DA Krasner started. So there's already been a 75% reduction. When DA Krasner started, he said he wanted to reduce the number of kids in placement. That number was about 630. That number has been reduced to 250 in the 2 years that we've been in this administration. So we focused on a lot of strategies. We also had a lot of failed institutions like Glen Mills, where we had to remove all of our kids because they were abusing our kids. There were other failed institutions as well. So even though we've been engaged in reducing the number of kids in out-of-home placement, these failed institutions contributed significantly to that dramatic reduction of over 50% in 2 years. We're also seeking to focus on reducing or dramatically increasing the number of young people we have who are diverted out of our systems. And we have a variety of new programs that we're focusing on. I'm not going to get into all the details. I just want to say this. In our community, we realized after searching heartily that there were a tremendous number of resources available in the community that had never been used in the juvenile justice system. And so we've gone to a variety of places to find some of those resources. We've developed a new program called Mile Up, for example, where young people come to the program and they're learning how to support running through a mentoring program for a Broad Street run that we have, a 10-mile run. And in the process, they use funds that they get through that program to reduce their restitution costs. We're working on a specialized program called Hope Works, where kids are engaged in coding, website design, GIS programs, and have trauma-informed coaching in that program. That program is based in Camden, New Jersey, across the river, but we're able to use it and work to do some specialized programming there. And the young people come out of that program with an opportunity to get jobs making over $30,000 a year. We're looking at Village of Arts and Humanities training programs along with stipends for painting and photography, fashion and music. Again, something new and different. We're also looking at our traditional program of youth aid panels, and we're looking to do something that John had talked about doing in his program in Houston, and that Philip was talking about in Seattle, which is having young people who have nonviolent felonies come into our diversion program, something that was thought of as not a very good idea in the past. We're bringing more young people into our diversion programs who have nonviolent felonies. We're also looking at youngsters who are not just there for their first arrest, but some of them may be there for a second arrest. We're looking at having new kinds of opportunities there. The other overarching principle we have for these programs is that once you finish the program under court supervision, many of our young people want to actually continue in those programs because they've helped them structure their lives. And so we're working with these programs to make it possible for our young people to continue in these programs that benefit them outside of the court supervision. So again, these are some of the overarching principles. We also are looking at, as we develop these diversion programs, early expungement to try and get rid of the records that young people have. We're looking at diverting young people, even though they've been in secure detention after arrest, even when they've been released back to the community, something again that wasn't done. So we're looking at new approaches. Again, we have, I think, 5 or 6 new programs. I'm not going to try and talk about them here in detail because they're somewhat confusing. Let me say this, though. One of the most profound things that's happened in Philadelphia, I believe, is that we've been able to, I would say, break the back of the school-to-prison pipeline. This was done by what's called pre-arrest diversion by the police department. Former Deputy Commissioner Kevin Bethel has worked diligently over the last 4 years to use pre-arrest diversion, diverting kids to prevention programs run by our Department of Human Services. And in the process, he had reduced the number of kids coming into the juvenile justice system by 2/3. At one point in time, we had 1,500 kids coming into our system from the school systems. That was reduced to about 500 because of this pre-arrest diversion program. Kevin not only has this program, but now he's a security officer for the school district. And we're looking at developing new kinds of protocols to deal with threats, for example, mass shooting threats that come into school system, so we can avoid the kinds of mass arrests that happen to children when they get involved in these kinds of events. So we're looking at new approaches, but for those who are interested in dealing with the school to prison pipeline, again, I recommend the program that John was talking about in Texas, which I think is showing really good results. And I also recommend the program that Kevin Bethel has developed here in Philadelphia, working in conjunction with the district attorney's office and a lot of other stakeholders across the system. We do not believe that we in the district attorney's office can bring about fundamental reform in our juvenile justice system by ourselves. We need lots of real good stakeholders involved with us. The court is a partner as well. But our goal is to take the numbers of kids in our juvenile justice system down dramatically from where we are at 2,400. Hopefully sometime during our tenure here under the Krasner administration, we'll reach 1,000 kids. And that would be real progress for many of us who believe fundamentally that most kids who come into the system leave the system with greater harms than what they came into the system. And we want those kids who do come into the system, who have to come to the system, to leave with better results and better off than when they came into the system. And we're going to have to work diligently to do that. Again, there are lots of specifics that I can get into. I invite those who are interested to contact sarah.shaw@phila.gov to find out more about our conference and what we're going to be doing at that conference. It's a progressive prosecution conference, but we invite all prosecutors who are interested in improving their approach to dealing with juveniles to come to our conference and have discussions with us about what kinds of things need to be done in the area of diversion, in the area of school diversion, in the area of direct file juveniles, and also in the area of dealing with children who have summary offenses. Those interested in dealing with young people who are young adults, ages 18 to 25, we anticipate having a conference in the fall to deal with that. So we don't want to try and bring everybody to the same conference for those issues. We look forward to working with many of you across the country as we continue to try and improve our juvenile justice system.
Bob, thank you very much. Let's clarify one thing about your prosecutors conference. Is the audience prosecutors only? So could people who are not prosecutors contact Sarah and sign up for the conference?
Well, at the present time, we're focusing on prosecutors primarily. If there are other people who are interested, please contact us. We haven't made that decision yet. In fact, we're meeting with Mark and others tomorrow to have some further discussion about that. So we'll consider that. If we have a strong interest by other folks who are interested in participating, we'd certainly give serious consideration to that. I know for a fact that prosecutors have a major role because we have the discretion to do things that discretion is completely within our control. But we need a lot of other stakeholders. And perhaps we need to also think about bringing some of those other stakeholders to our conference. We're still at the formative stage, so we'll give serious consideration to that.
Great, thank you very much. Now we're going to take questions, and people are already sending in some questions. While you think about it and start sending your questions in, there were some that came in while people were talking, and I think one is for each of the panelists. All of you have talked about effective diversion programs and the progress that you've made. Several people asked, how do you explain the diversion programs to victims of crime, and what has been the response by law enforcement officers? And John, I'll put you on the spot first since you were the first to speak, and then we'll go around to the other speakers. So what's been your experience?
First of all, when we don't divert the violent crimes involving guns and things of that nature, just a philosophical reason. Now, however, the sexual assault diversion, you would imagine, well, wouldn't that be a concern? That's one of the reasons why we zero in on sexual assaults that occur within the home regarding siblings, step-siblings, cousins, and we make sure that there's not going to be a lot of blowback because we do have to be very conscious of victims and their concerns. But the problem in the juvenile justice system is there's so many charges previously that don't have to do with victims. However, in the school districts, we did in the beginning have some resistance from a lot of the campus officers. That's why trainings were important, massaging those relationships, making sure they understand it. And we also, as a parent, I understand if your child is assaulted in a school, you expect bloody murder, but you're also not being objective. So I field every call from every parent that the kid was a victim in a school and talk them through our philosophical change. So yes, there are bumps along the way, but we think it's worth it.
Philip, what are your thoughts?
Oh, yes, Mark. My thoughts on that are a couple things. I just want to say, like John, for the majority of my prosecutor career, I did adult cases. In fact, I didn't actually do juvenile case work until the last 3 years of my career. I've been doing this now for going into year 12. With regards to diversion practices and how do you address that with victims, I think the most important thing that I do with those victims, or what we do, is we're very transparent about what our state, Juvenile Justice Act focuses on, which is rehabilitation. It is, it is quite different from the adult system that we have here. Rehabilitation is what our commitment is to youth who come through the system, and how do we achieve that? Everyone's going to always have different ideas about what that means, what that should include. But those are always difficult conversations, but I think it's important to be transparent and open with victims of crime to let them know this is why we're doing this. This is why we're doing diversion. Even educating them with a little bit of history of why we are where we are now, why would we be doing this, but also trying to be mindful of what would you like to have happen as well, right? Because we want to try to do as much as we can to honor and also respect the victim in this process, because always trying to make people whole is always going to be a challenge at the end of the day. With regards to support from law enforcement, we've had plenty of support from law enforcement with regards to the FIRST program. I mean, they're the first responders, right? Especially to the FIRST being the domestic violence situations, right? They're the first responders. They can see when, one, there are, serious issues with the home, two, maybe inconsequential, arguments or minimal type of arguments or violence going on in the home. And I can tell you that I've heard from a couple officers, some of them, struggle with the fact that they have to arrest the youth because of what's going on in the home. And so being able to have that option to have the parties cool down by sending a child to a respite center without actually having to book and detain them, that's great. I will tell you, the decision to do that, though, isn't necessarily made up to given to the law enforcement officer to decide who goes to FIRST, who doesn't go to FIRST. They get brought in, and then the FIRST team is the one who takes a look at, sort of that initial report and makes that assessment of, let's send them in this direction. So it's really the other independent professionals who make that decision. I also saw a question too that popped up real quickly. How much of the court or support of the bench do we have with the FIRST? We have the full support of our bench, elected officials, to support that program. With CEDAR, that was a program that we specifically designed for ourselves, so that we could kind of control, how it's actually going to function and how it's going to work, and how it might be decided whether a case is successful or not. But with regards to services on CEDAR, services determined for a youth, that is determined by the probation officer and then the community outreach team. For example, the credible messenger, who both chime in and really educate the attorneys about what's needed.
Thank you. Bob, briefly, your thoughts?
Yes, police officers can often hear the message better from other police officers. Working with Kevin Bethel, Kevin not only worked with police officers here in Philadelphia, but he's carried the message to people across the country. When we worked together in Washington while I was working at OJJDP, we had panels of chiefs from across the country who came to listen to him talk about how critical it is for police officers to understand adolescent development and how traumatizing they were by bringing young people into police stations and doing perp walks out of schools. Police officers listened to him. And because he also has a video of his daughter going through the arrest process, it's a powerful thing. And so I think one thing I'd encourage folks to do is have cops who are really good, talk to other cops who've been through the process and understand the importance of reducing the number of kids going to the system unnecessarily.
And if I can add to that, because I was very much influenced by Kevin Bethel. I, as you know, Mark, saw him in Georgetown with you. And if you think Bob is charismatic, you should see Mr. Bethel. I mean, he will sell it to and he's amazing. And so that's how I got the idea to do the video of my son, because I saw him do it with his daughter. And I told him that when we were together in Seattle. He's amazing. The other thing I'll add really quickly is that my message at the end to law enforcement, and I think I kind of have credibility with law enforcement because I did violent crime for so long, is that we are trying to change the culture of a nation where we're all kind of under attack, law enforcement as prosecutors. And what better way to gain favor in our country than to help youth? And so that as opposed to arresting youth, they're protecting youth in the schools. And forging relationships. And by benevolence and concentrating on the peace aspect of being a peace officer, we might be able to change the wave of how folks view law enforcement in this country. So it's actually an opportunity, I think, for us to mend some fences and to get intel within the communities to find the ones that we are fearful of.
Thank you. All right, we have a number of questions coming in. So I'll ask some questions and then we'll see whoever wants to answer, just let us know. One question is, in my community, there's been an increase in gun violence and gang involvement with young teens. How do you handle these types of issues and applying diversion ideas while also trying to sever the gang ties that some juveniles develop? Who would like to address that?
First of all, what probation officers tell me is, to piggyback on the last discussion, that if they ask gang members that are reformed gang members what their number one profession they'd like to be a part of, it's law enforcement, because they want to be part of something. And we do have a gang court here in Harris County where that the courts are involved in, and we attempt to work with gang members. I will say this is, when it comes to firearms, armed robberies, things of that nature, we don't divert them. We are very careful of those, and they're one trigger away from a capital murder. And we do have a real epidemic here in Harris County. We had 400 robberies last year. So that's where we draw the line, but we believe the message is consistent. If we are progressive in all these other crimes and funnel them out of the system, then the court system can be for these types of cases. And then the judges can do some innovative things with them.
And I would, just to add to that too, just to John, same thing. We don't, King County Prosecutor's Office does not divert those, gun possession cases, violent robberies, assaults. Typically for us, most of our standard diversions, again, are going to involve maybe more of the lower risk domestic violence situations, lower level misdemeanor crimes, and so forth for us.
And Mark, I would add that it's pretty standard. I don't think there are very many prosecutors who are diverting gun cases anywhere in the country. So we're not doing that either. But what we need, and I'd like to stress, what we desperately need in this country is places where we can send young people who've been engaged in extremely violent behavior and recognize that we're not just warehousing them, and that when they come out, they're going to be better than when they went in. What we have had is a pattern of taking particularly young men of color and putting them in these warehouse kind of situations, brutalizing them and bringing them out and putting them back out on the streets, and they're worse off than when they went in. Glenn Mills, for all the good that it was doing, we thought we had a good institution. It turned out a case where touch for attention or beat kids up if they didn't do what you want them to do was standard practice. Where are the best institutions for us to have these kids go to? Where are the places that are going to rehabilitate them rather than abuse them? That's something we really need to know, and we need to be having conferences about developing those kinds of institutions as well, rather than simply where do we put them away and why do we have to put them in prison? I mean, prison's not really doing much for them. It's warehousing them, and also it's not rehabilitating them. So we need to think about what we're going to do for young people in that regard.
Thank you. A number of the questions have come in that are state-specific or jurisdiction-specific, and I'm going to not likely to do those. I encourage people asking those questions about Philadelphia or Texas to contact John or Bob directly about that. Let me look at some questions of a broad approach. Some people have asked about judges, bringing judges to the table. One participant says, I'm struggling with a judge who will not sign off on some misdemeanor referrals and wants them to come before them. How do you handle judges who are resistant to these kinds of reforms? Anybody?
Bob, I would say from our point of view, some of these things are completely within the discretion of the district attorney. They're not judicial, there's no requirement of judicial consideration. Clearly, I want to cooperate with judges. We're not here to diss judges. Judges have to make tough decisions all the time as well. When we make tough decisions about diverting cases, we take the responsibility for what happens to youth. So we're definitely going to follow those cases. We're definitely going to do research to make sure our programs are working and effective. We're definitely going to keep data to show that we're being effective. We're going to discard those programs that don't work well and keep those that do. But we need partners. And I'm willing to have a conversation with any of the judges we have here in our jurisdiction or across the country who want to help us in this problem. The judges have a big problem, if you ask me. So many of our kids in Pennsylvania are being put in placement for technical violations of probation. They're not being put there for new offenses. To get the judges on board with dealing with that problem, the problems they're having with making judgments about which kids are the best ones to send away for placement.
Anyone else?
I know that our process in Seattle for diversions or that decision being made is within the sole discretion of the prosecutor, assuming it meets certain criteria by law, okay, in order to send it. So we don't have to go through a judge's approval to be able to send a case through diversion. It is up to us by law to simply refer that to a diversion committee who will decide whether or not the case will be accepted for diversion.
Great.
Same here in Harris County. We're fortunate that all three of our juvenile judges happen to be progressive, so they're supportive of what we're doing. But our goal is to make sure that youth don't get to them. And same in our jurisdiction, it's our sole responsibility and discretion.
Great. All of you have talked about the importance of collecting data to understand if the reforms are working and who is being impacted. What are you finding about race in terms of the drops in referrals or drops in prosecutions going forward? Are these reforms equally or equitably affecting young people of color as well as white youth?
I will say that to just jump in on that real quick, and again, you can find a lot of the information about King County's programs and some of that data that I'm talking about today online. I know that when CEDAR came about, when we were looking again at sort of those crimes of assault, the robberies, the thefts, some of the higher end property crimes, I believe it was north of 80% we found that those involved kids of color, which is why we thought there is an incredible need here to address a lack of community support or services for those families, and what can we do to do that? And we were able to develop that through the Credible Messengers group and through other partners within our judicial juvenile justice system. And so for us, that's, for example, a number that we looked at when trying to develop CEDAR.
I would just add racial and ethnic disparities have remained pretty constant across the state of Pennsylvania. The only place where they've decreased is in Philadelphia. And the primary reason for the decrease, and it was slight, it wasn't a major decrease, was because of the reduction in the number of kids coming into the juvenile justice system from our schools. So I think school diversion, police, pre-arrest diversion has the best hope for reducing some of the racial and ethnic disparities. Otherwise, the secure detention facilities have only increased in racial and ethnic disparities in the last several years, along with overall reductions in placements across the country.
Yeah, Bob, I agree with you. And the stat that was really impactful for me, and I'm sure y'all do the same thing, is part of my reform and within my makeup was listening to activist groups, Texas Disabilities Rights, and folks of that in our jurisdiction, that and many more. The stat that was impactful for me was that within school filings, 78.2% were minorities and 5% had some type of disability. And what I would tell folks is, I'm not going to get into the why, it's just not acceptable. So one of the reasons why we're so passionate about reducing that population is, I don't know if the disparity will be reduced, but if the numbers are reduced, that by definition means we're putting less folks of color into the system.
Let me ask the next question. Bob, you mentioned the adolescent brain development research, and all of you are aware of the research and understand how it affects your decisions on diversion. Have you found that juvenile court judges and public defenders, as well as your own staff, are knowledgeable about the adolescent brain research and what the implications of that research are for how you handle cases?
My answer is that for the most part, this knowledge about adolescent brain development, which has been around now for almost a decade, is not well understood by judges or by prosecutors or public defenders. They're aware of it. Most have been to a training or two about it, but there's not a good understanding of exactly how it affects the behavior of children. And also research on trauma, which has to be a companion piece, is also not well understood. People know that it has something to do with the behavior of children, but they're really not able to tell you exactly what, nor are they able to understand what kinds of programs need to be developed to address it.
We're running out of time. There are other questions that we're not able to address, but we can continue this discussion on JDAI Connect. I want to thank all of our panelists, John Jordan, Philip Sanchez, and Robert Listenby, for your thoughtful answers, and for your descriptions of what you're doing in your jurisdictions. And I encourage people participating in the webinar to contact you directly if you want more information about that. This is obviously an area that there's lots of interest in, and people still have additional questions. For all of you participating in the webinar, please stay on. There will be a brief survey and evaluation coming up as we finish. It's now 2 o'clock. Thank all of you for attending this webinar.